Nancy Munson Spirit of FOI Awards. These awards honor Texas journalists and news organizations for outstanding efforts that uphold First Amendment principles and improve the public's awareness of transparency laws. We have winners and honorable mentions to mention. That's okay. Honorable mentions to announce in both of our market size categories. Class A for smaller markets with a population of 500,000 or fewer, and then Class AA for the larger markets with a population of 500,000 or greater. And we'll ask the winners to come forward and receive your trophy and get your picture taken, all of that. So in the smaller market category, the two honorable mentions go to the Odessa American and the Corpus Christi Caller-Times, both of whom always do great work in this area. But the winner in this classification is KRIS-TV Channel 6 News for its coverage on the high rate of case dismissals in a local prosecutor's office. One of the judge's comments said that Nueces County residents should be outraged that its local prosecutor's office is seemingly settling criminal cases in order to qualify for various grants. At the same time, however, they should be pleased that KRIS-TV has exposed this nonsense, and in a series of 3 reports, the station documented these disposals with local officials refusing to explain themselves. So congratulations, and thank you also for a great panel participation earlier this morning. And in our larger market category, honorable mentions go to El Paso Matters, who we also heard from this morning, and the Dallas Morning News. The winner in the larger market classification is a joint effort of the Austin American Statesman and KVUE-TV for its coverage of the Uvalde shooting and the subsequent events. And somebody from somewhere is going to come get it. There, okay, yeah, okay. there we go. Okay. One of the judges made a comment on this submission that in the aftermath of the Uvalde tragedy, government entities worked to block the distribution of information at every turn. It should not be that way. It wasn't enough that parents lost their children, but for days, law officers told stories about heroes. For days, law officers told stories about heroes, but the reports from the governmental agencies were not forthcoming. Again, according to the judge, a transparent government would have fallen on its sword and acknowledged its shortcomings, and yet that is not what happened, and that is why we need journalism. So again, congratulations to everybody involved in that project. And our next award is the James Madison Award. I'm going to ask Stacy Allen to come forward and present that award for us. So I think there he is. Okay, yeah, there he is. Yeah, come on. Stacy is a partner in the Jackson Walker Law Firm. The Jackson Walker Firm has been a supporter of this organization for literally as long as it has been in existence. I've been a terrific supporter of this organization. Stacy himself personally is a stalwart volunteer and supporter of the organization, and he's going to come forward and take the next step.
Good afternoon. It is both a pleasure and privilege to have been asked to help present the James Madison Award to Bill Girdner, who has spent a lifetime of service in defense of the First Amendment and in particular open access to government records. If George Washington is the father of our country, James Madison is the father of our Constitution, and indeed the author of the Bill of Rights, which of course includes the First Amendment that we come here today to celebrate. Inherent in the right of a free press is the right of people to know what their government does in their name and what it spends in doing so. And open access to government records is the most effective and direct way to learn those things. The Freedom of Information Foundation of Texas bestows the James Madison Award on those who demonstrate outstanding commitment to the principles of the First Amendment and open government. Bill Girdner, as editor of the Courthouse News Service, has worked to require timely news media access to court filings in Texas and indeed across the entire nation. He is a journalist for more than 3 decades and has spent much of that time battling state court officials over access to new filings when a court receives them. And this has led to significant First Amendment victories in numerous trial and appellate courts. During the digital era, Bill has sought to compel court clerks to provide the news media with same-day access to e-filed complaints, petitions, and motions as a matter of First Amendment law. You would not think that that would be that difficult since we are now e-filing those documents, but as we've been discussing at my table, it can take upwards of a week or even more to finally be able to have access to those documents, and Bill has been a stalwart defender of the people's right to know in that regard. When nominating Bill for this award, my law partner and longtime FOIFT board member, Paul Wattler, observed that at a time when traditional press outlets have dialed back their commitment to media access cases, Bill single-handedly has been the impetus behind an evolving body of law addressing the right of news media access to electronic court filings. So without any further delay, please welcome me and welcome Bill. Please join me in welcoming Bill to the dais to receive the 2023 James Madison Award.
Thank you, Stacy. I was telling Kelly that I haven't spoken publicly since high school, and I ran for ASB president and lost, so we'll see how this goes. Your invitation to me has forced me to, in a sense, justify my actions for the last 15 years. Why would I file so many lawsuits? Why would I spend so many millions of dollars in attorney's fees for access to the court record? Why would I take on a national battle against state court clerks who are paid by the public, who use lawyers paid by the public in order to fight against public access? So I want to read you a quote from Judge Bobby Shepard on the 8th Circuit that will help understand that. And this was in one of our cases against Missouri, and he said this last year from the bench. He said, "There was a time when, and some in this room may remember it, when you took a pleading to the courthouse and the clerk stamped it physically, and it went into different bins, and it was available immediately." So that's the why. That tradition of public access is part of what makes our courts unique. And the public nature of our courts is what makes them a central pillar of our democracy. That bin that Judge Shepard was talking about, I've seen it in courts all across the nation. It was either on the counter, the clerk's counter, or behind it. Journalists covering the courthouse checked it every day, like a fisherman checks his nets, because it held news. So the attack on that tradition has come from state court clerks in the transition from paper to electronic filing. Now, I want to put in a caveat here, because some of the clerks have been great. The clerk here in Travis County has been very fair to us. But in the main, the state court clerks in this transition pushed the press and the public back behind clerical work, back behind the processing of the new complaints. That takes time, and it can take from a day to 2 weeks. And so I compare, and I've done this a number of times, news to bread. It's fresh on the day it's made, it's stale the next, and after 2 weeks, bread is good for croutons, and the news is just not news. Now, we're not opposed to clerical work. We don't think it's unimportant. It's very important for a court to run smoothly. We just say it can be done afterwards. So, in the federal courts, for example, in all 4 federal districts here in Texas, when you file a pleading and you press the submit button, it becomes available immediately. So most federal judges, the great majority, understand very well how their own courts work. And I wanted to give you a quick quote from Judge Browning in the District of New Mexico, where we also have a case pending. And what he said was, let's see, things are filed here in this building all night long, and it's immediately accessible to the public. He's right. That's true in federal courts, and it's true in a growing number of state courts, but far from all. We have litigation going, and it's a long list. First Amendment litigation going in Idaho, in Oregon, New Mexico, Iowa, Minnesota, North Carolina, Virginia, Maryland, Ohio, Pennsylvania, and we won a really good decision, I think it was last year, in Vermont from the district court judge there. And the state attorney general in Vermont has appealed that to the Second Circuit, so we also have a case pending in the Second Circuit. Now, I want to give you a sense of how this litigation goes, because it's often devolves into trench warfare. Many of you in the audience will know that in order for a claim to proceed, we need to show harm. And the best evidence of that harm is often held by state clerks in the form of their statistics on when a case is submitted and when the case is processed. The lag time, the period I've talked about, the 1 day to 2 weeks, between those two events is the proof of our harm. So, as you might suspect, the clerks are very reticent to give up those statistics. Now, it happened here in Texas, where we had litigation going against the Office of Court Administration until recently. We asked the state AG for those statistics, and they refused. We moved to compel in front of a federal magistrate. The state AG came into court with an affidavit and said, this is impossible to produce. These statistics are impossible. That's the word they used. So I was discouraged. How are we going to prove our harm? But that's the nature of litigation. Sometimes you get lucky. So a couple weeks later, into my inbox came a spreadsheet from the court clerk here, discovery from the local court clerk here in Travis County. And it included a spreadsheet. I clicked on the spreadsheet, and lo and behold, in color coding was the very information, the very statistics we've been asking for, showing submission dates and showing processing times, thus showing our harm. So it was quite possible to produce those statistics. Our lawyers from Jackson Walker, Matt Dow, and John Edwards then took that example back to the AG, and the staff promptly produced the statistics they had said were impossible to produce. So the wheel of events, however, has continued to turn here in Texas. And Chief Justice Hecht and the Supreme Court recently, this month, put in place a rule saying that the clerks, the court clerks who are elected officials here in Texas, must give public access to the new pleadings on the business day on which they are received. It's very clear. There is an out unless that is impracticable. But we know that it is practicable to produce that information on the day it's received, because the vendor, Tyler Technologies, does that here in Travis County and does it in other state courts nationally. So we know the clerks can comply with the rule requiring that they give us public access on the day that the pleadings are received. On that basis, we dismissed our case against the Office of Court Administration. So I want to kind of wrap up here with another good news story. In the Eighth Circuit hearing I mentioned earlier, another judge, Judge Ralph Erickson, asked the lawyer for the director of the Missouri Office of Court Administration, asked this question. Quote, "What we're saying is that, for about 230 years, you can walk into a Missouri courthouse, into the clerk's office, and say, 'Hey, can I see what's been filed today?' And now, all of a sudden, you can't, right?" So the lawyer for the state in Missouri said that would be interfering with a judicial proceeding. The Eighth Circuit ruled in our favor, overturned the lower court judge's ruling of abstention, and this summer, a new Chief Justice came into office in Missouri, and since then, there's been a 180-degree change in the wind. The state is now headed towards a federal-style system of access, where when a new case is filed, it is automatically processed and becomes public immediately. So hopefully, that's a harbinger of change. So that is a piece, okay? That is a piece of what I've been doing for the last 15 years. And now, if somebody asks me to justify my actions for that period, I can hold this up. Thank you, folks. I really appreciate it.